Hey folks, I'm Robert Scavone Jr., the host of Summarily, a podcast for busy lawyers. Welcome to our new YouTube channel. Summarily offers a selection of case law updates, practice tips from experienced lawyers, continuing legal education courses, and insightful conversations with judges, lawyers, and legal experts on a variety of issues. A new episode is published every week. You're about to watch a snippet from the latest episode. You can find the entire episode at summarily.buzzsprout.com or by searching Summarily wherever you get your podcasts. I put a link to the podcast in the description box below. Please like and subscribe to Summarily so you don't miss any of our shows. Enjoy the clip and the podcast. And remember, folks, case law is one word. Welcome. This week on Summarily, I interviewed Adam Feldman, the creator of Empirical SCOTUS, a blog designed to look at contemporary and historical Supreme Court issues at an empirical level. Adam and I discussed the sluggish rate of opinions this term, how oral argument has changed, and what the data says about the ideological splits on the court. This is a short clip of our conversation. You can find the entire episode on the podcast. I put a link to the podcast in the description box below. Enjoy, and thanks for tuning in.
And another thing that I've been looking at is tracking oral argument, speech and discussion, and looking at the justices' amount of engagement in oral arguments. And a few things that I found this term that are interesting. One, that Justice Jackson is really setting the upper bar for engagement in oral arguments, which is very odd for a first-year Supreme Court justice, just looking statistically at the history of the Supreme Court. But also at how the Supreme Court's becoming, or oral arguments are becoming more of a discussion forum for the justices, not only for hearing the attorneys speak, but also possibly for getting some of their theories or policy questions out that end up being really lengthy talking turns that aren't designated for the attorneys. When we think about the purpose of oral arguments, a lot of people think it's for the attorneys to get their arguments out, but as we're seeing, that's not necessarily the case.
In Dobbs, Thomas was in the majority, so presumably he was the justice as most senior that assigned the opinion.
Right.
Any idea why he chose Justice Alito to write it as opposed to maybe Justice Barrett, or some other justice? Yeah,
I mean, I think that the only other justice that could have written that opinion in Thomas's eyes is probably himself. And I don't think he could have gotten a majority in the same way himself, because when you look at his concurrence, he was really looking to push farther than
on substantive due process.
Yeah, than Alito's opinion. So I think Alito was the justice who was going to go furthest in terms of putting up barriers against constitutional right to an abortion, aside from himself. And so that, Alito was kind of the most likely choice there. I think that the other justices were probably fine with that, because Alito had, aside from Thomas, had the most seniority on the court in that majority. So so there's that kind of history of the court argument there also.
Mm-hmm. Do you track any data for things that go on outside of the court with the justices? So, for example, I'm thinking like the amount of times that the justices appear for speaking engagements. Do you track that kind of stuff?
I don't. But one of my friends runs a nonprofit called Fix the Court, and Fix the Court tends to have all of their travel data and more kind of interestingly now all of their financial disclosures to the extent that they're released show up there. So they're a watchdog group, and they track that.
The percentage of advocates that appear for OA is generally very high for white males. What's the percentage of advocates, in the past 10 years or so that have been women or minorities? And is there a trend toward more women and minorities presenting before the Supreme Court?
Yeah, so I mean, you usually have about 80% men to about 20% women that are arguing. I don't have the numbers from minorities, although SCOTUS blog oftentimes tracks that. But we're seeing, probably an increase over time in terms of the male or the female to male ratio. Kind of seeing more females argue, but it's moving very slowly in the upward direction. So, in terms of kind of equity, we're not near there.
Right.
And some people would say that that's kind of built into the cake of the Supreme Court because it's a very hierarchical power structure in terms of the attorneys. And so once you've solidified your place among the SCOTUS elite, then you kind of have a position there. And
you're the go-to.
Right. And that's oftentimes historically been men.